1. Introduction. This book is about liberty. It is about the lawful and unlawful means by which government acts in depriving an individual of his liberty. History teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words. The contest for ages has been to rescue liberty from ahuuahkhuu executive power. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrests and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills which turn out thousands of new laws every year. The passion of modern legislatures to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or summons. But it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of these laws. No one can be safe to leave their home or travel about for fear of being subject to thousands of unknown laws in which he could be instantly arrested for transgressing. One law review writer states the problem as follows. People no longer live their whole lives in the village in which they were born. They pass freely from place to place, and in transit go through innumerable towns and villages. The risk of being arrested on sight, because one's conduct contravenes some regulation which the wisdom of the local solons deems necessary, is appalling to any thinking person. It would be impossible to know at what moment one might become amenable to arrest. A revolution in England and the revolution of the American colonies are said by high authorities to have been largely influenced by promiscuous seizures and searches of persons and property. The history of our ancestors over the centuries teaches that a people cannot be free where the executive power can arbitrarily arrest or imprison citizens, or ransack at will the properties of the people. The executive power is limited and guided by the jaw of the land, or due process of law. If it was a restriction upon the King of England, it must be so for every petty officer today. In many of the treatises on the law pertaining to the rights of citizens, and in many of the older and Banier Crown cases, we find the declaration, the law is very jealous of liberty of citizen. What law is it that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his peril. This law also prescribes how arrests are to be made, and the restrictions involved. Unity of Pennsylvania Law Review, Volume 75, p. 491, April, 1927. 2 Night 1. Baker, 117 Oregon 492, 244 Pacific 543, 544, 1926. 3. 2. Definition of false imprisonment. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar, Henry de Bracton, 1200 to 1268, tells us that false imprisonment is one of the oldest violation of rights known. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. Point 1. False imprisonment is classified as a tort under the common law, and also as a crime. 2. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. In Treatise practice of the law it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment. Or malicious prosecutions. 3. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on of hands is not necessary to constitute an unlawful detention. For thus the only essential elements of the action are, 1. Detention or restraint against one's will, and 2. The unlawfulness of such detention or restraint. 5. In his treatise on the law o/torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint upon a man's freedom of locomotion. 6. Blackstone. In his commentaries on the law, 3 by COMM 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison, or in a private house, or in the sloex, or even by forcibly detaining one in the public streets. 7. SMDS Foundalion 0/Legal Liability, Volume 1, p. 12, citing, Bacton's Notebook, Volume 2, p. 314, 1229, pi. 465 2 Kroeger. Passmore, 36 Mont 504, 93 Pacific 805, 807, 1908. McBeath v. Campbell, 12 S.W.2d 118, 122, Texas 1929. 3 Joseph Chitty, ESQ, The Practice o/the Law, Volume I, Chap 2, p. 47, London, 1837. 4 Hamer v. Bieber, 271 MO 326, 197 SW 68, 70, 1917. 5 Sergeant v. Watson Brothers Transco, 244 Iowa 185, 52 N.W.2d 86, 93, 1952, Sinclair Refining Co. v. Meek, 62 GA 850, 10 S.E.2d 76, 79, 1940, Southern Rico in Kentucky v. Shirley, 121 Kentucky 863, 90 SW 597, 599, 1906. 6 Thomas Cooley, Treatise on the Lawful, Volume 1, 4 th ed. 109, p.345, Mainz. Huntington, 276 f.245, 248, 1921. 7 Cited by Fox v. McCuman, 205 Iowa 752, 21 8 NW 499, 501, 1928, Sargiel v. Watson Brothers Tramp. Co., 244 Iowa 185, 52 N.W.2d 86, 93, 1952. 4. Thus any type of detainment or confinement of a person, or restriction, or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen, or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. 8. In reviewing several EXT book definitions on false imprisonment, the Supreme Court of North Carolina stated, false imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. 9. A rather complete description of what does and does not constitute false imprisonment was given by T.B. Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All tie is necessary is that the individual be restrained of his liberty without any sufficient legal cause therefore, and by words or acts which he fears to disregard. Lo. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. 8 Griffin v. Clark, 55 Idaho 364, 42 p. 2d, 291, 301, 1935, citing, Cordelf. Slandered Oil Co., 131 Kansas 221, 289 p. 472, 473, 1930, Loneson v. Tompkins, 13 Federal Co. 840, 853, number 7416, 1833, 9 Rail v. SIOM, 174 NC 588, 94 SE 434, 440, 1917, 10 Garney Ewell, Squires, 62 Kansas 321, 62 Pop.Lu 5, 1006, 1900, Croegerv, Passmore, 36 Mont 504, 93 Pacific 805,807, 1908. False imprisonment has been well defined to be a trespass committed by one man against the pen on of another, by unlawfully arresting him and detaining him without any legal authority. L1. The law sets such a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. 2. All the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. 13. Thus any illegal restraint of one's personal liberty by the act of another, gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie any restraint by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual usually made by an arrest, and physical custody or restraint is not essential to the effectuation of an arrest. So if an officer tells a person that he is under arrest, and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty, and if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered. In such a case there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit. 11 Regood v. High Grade Seed Co., 47 Federal Sup. 290, 294, 1942. 12 Giddens 1. Slaw, 154 GA 54, 113 SE 386, 388, 1922. 13 McCall, T, R.V. Good, 216 Pat 473, 65 All. 934, 935, 1907. 5. Under the belief and impression that submission was necessary. 14. The following definitions will provide further insight into the nature and elements of false imprisonment. false imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used the word false seems to be synonymous with unlawful. 1. Any exercise of force, or expressed or implied threat of force, by which in fact the other person is deprived of his liberty, compelled to remain where HC does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person, without warrant, or by an illegal warrant, or a warrant illegally executed. 17. Any restraint, however slight, upon a knower's liberty to come and go as he pleases, constitutes an arrest. 18. Length of time requirement. The tort or wrong of false imprisonment occurs the instance that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before the LORL can be claimed. False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any. 14 Johnson v. Norfolk N.W. Rico, 82 West Virginia 692, 97 S.E.189,191, 1918. 15 Mahan 1. Adams, 144 MD 355, 124 A 901, 904, 1924. 16 Blackett Clark's Greensboro Incorporated, 263 NC 226, 139 S.E.2D 199, 201, 1964. 17 Nos v. Ritchie, 155 SE 127, 128, West Virginia 1930. 18 Turney v. Robbs, 42 GAF, 104, 155 SE 112, 1930. 6. Time, whereby he is deprived of his personal liberty. 19. Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment. Even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. 20 Where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time. Duration is not a factor in making an arrest. False imprisonment is defined as an act which, directly or indirectly, is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration, makes the actor liable. 0 The other point 21. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. 22. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at common law, and relief by the party aggrieved was obtained by an action for trespass. 6 Et armis with force and arms. Point 23. The illegal arrest of a person without a warrant, or under an invalid warrant, entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did in Murphiv. Countess, 1 Har. Del, 143, in an action for trespass, assault, and battery, and false imprisonment, the court held that the plaintiff could recover, not merely for the time TB Constable was bringing him to jail, but for the whole period of his imprisonment. And in Mandeville v. Guernsey, 51 bar, NY, 99, the court said, the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which result directly from the wrongful act. 24. Unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent, and absolute rights, which damage results as a legal consequence. 25. 19 SJNC/Air Region, NG Co. V. Meek, 62 GA App. 850, to SE 76,79, 1940, citing, 3 by Commander 127, 12 Amer and, ENG Encyclopedia O/Law, 72-1, 19 Cite.319. 25 American Jurisprudence, 2D, Arrest, T1, p. 696. 21 Sergeant V. Watson Brothers Transco, 244 Iowa 185, 52 N.W.2D86, 92, 1952. 22 Co. RN Ishweislow, 215 MD. 64, 137 ATI.2D 170, 173, 1957. 23 Medgens v. Huntington, 276 Federal 245, 249, 1921, citing, 3 Blackstone, Commander 127, 4 Black Sloan, Commander 21-8. 24 KN Iktrabaktra Steamboat County v. Cusack, 172 Federal 358, 360-61, 1905. 25 Mainz v. Huntington, 276 Federal 245, 248, 1921, citing, Adler v. Fenton, 24 Howe, 65 U.S. 407, 410, 1860. A false imprisonment generally includes an assault and battery, and always, at least, a technical assault. 26 An unlawful arrest, imprisonment, and prosecution of a person can cause T-bar person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress, or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. Upon the subject of damages, the law specifies FWO kinds of damages or divides them into 2 classes. There are what are called actual damages, then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are also called compensatory damages as they compensate the injured party for the actual injuries sustained, and no more. Punitive damages are those that grow out of the wantonness or atrocity, or aggravated by the act. They are the injuries and sufferings that were intended, or occurred through 7. Malice, carelessness, or negligence amounting to a wrong so reckless and wanton as to be without excuse. 27 These are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for the damage caused. Thus, where a man was illegally arrested by a police officer, and was placed in a patrol wagon in which he was taken to the central station, it was held that the 2 officers in charge of the patrol wagon were liable, along with the arresting officer, for false imprisonment. 28. Malicious prosecution. In many cases of imprisonment or wrongful arrests, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the 2 charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements, enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. 29.1 Description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have proximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and 26 Black 1. Clark's Crunsborough Incorporated, 263 NC 226, 139 S.E.2D 199,201, 1964. It has been said that an illegal arrest is an assault and battery, SLA UI. Robinson, 145 MC 77, NA, 2D, 260, 262, 1950. 27 Ross 1. Leggett, 61 Michigan 445, 28 NW 695, 697, 1886. 28 Cook 1. Hoslings, ISO Michigan 289, 114 NW 71, N, 1907. 29 Snyder I. Thompson, 134 Iowa 725,112 NW 239, 241, 1907, 35 CJS, false imprisonment, 4, p. 625. 8. With malice. In an action of this type the burden rests upon the plaintiff, THONC bringing the suit, to establish each and all of the following propositions before being entitled to recover, to wit, 1. He was prosecuted in a criminal proceeding or civil suit, 2. Defendant instigated such prosecution, 3. The prosecution terminated favorable to the accused, 4. Defendant acted without probable cause, 5. Defendant acted with malice, and 6. Damages that were caused. 30. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail, and without any charge preferred against him. The defendants insisted his complaint was bad as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There is a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. There is a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious. There is a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial, without legal process, it is false imprisonment. LL. An arrest or imprisonment can be malicious or false, but not both. In a case of malicious prosecution, the arrest or detention is procured from malicious motives and with improbable cause, but was done under lawful process, whereas in false imprisonment the detention is without proper legal authority. 32 One may be legally arrested for some alleged reason, but done maliciously. If he is found to be not guilty, he then has a case for malicious prosecution but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not he has a case for false imprisonment but not malicious prosecution. If this is done with malice, it would add punitive damages to the suit. In describing the distinction between these two charges, the Supreme Court of Oregon stated that foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. 33. In other words, the want of authority is an essential element in an action for false imprisonment, whereas malice and want of probable cause are the essentials in an action for malicious prosecution. 34. Somewhat different to the wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose, in which malice or ill will may also be a factor. The term malicious arrest is used in some cases instead of malicious prosecution, but the latter is broader in scope. 30 SRG NL1. Wall SOIL Brothers TRRLLLSP Co. 244 Iowa 185, 52 N.W.2D86, 91, 1952, Cox 1. Caccio, 96 So.2D 872,874, 1957. 3T Color L. Lotrand Others, 35 IND 285, 286-87, 9 AM Republic 735, 1871. 32 Stalling SI. Faust R. 119 CAL.app.2D 614, 259 P.2D 1006, 1009, 1953. 33 Stat I. Williams, 45 Oregon 314, 77 Pacific 965, 969, 1904. 34 Row RTSV. Thomas, 135 Kentucky 63, 121 SW 961, 962, 1909. 9. 3. Arrest without warrant. The law of the land, the authority to arrest without warrant was rather limited and well defined at common law. A law which has been made part of our constitutional law in the due process provisions. The common law rule on arrests is based on experience and common sense. As a general rule at common law, an arrest could not be made without a warrant. Thus the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter, in delivering an opinion for the Supreme Court of Michigan, as follows: the law governing this case is elementary. Except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without a warrant. 1. The objective in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrests had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. I. Cook v. Hastings, 150 Michigan 289, 114 NW 71. 72, 1907. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obvious and well known. Therefore everyone's liberty was safe, since all knew for what reason they could or could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact? Or if the law on arrests can be changed by statutes? By the Due Process Clause, the common law governs what the law on arrest is in this land, and where it exists the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. Officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter.
Gratitude, gratitude, gratitude. Part 1. Part 1. Yeah, we get about 30 minutes in when I want to really put our people to sleep. I know our people. However, we are bring some information forward in an effort to, maintain clarity. Yeah, man. So again, to the people over there on Nantucket Island, yeah, man, the Commonwealth of Massachusetts, that area. We say judicial notice, we say public notice, we say basic notice. Yeah, man. And for the common folk, choose to apply yourself. Choose to apply yourselves. Yeah, man. Salute to a good brother them out there where upgrade them thing and improve themselves. Salute to the platforms out there. Just the same. Warwick Kyle TV. Why brother, boy, lit it up out there. I don't know if I and I alone I see it, but they are step up. They are game on a level where we have to say yeah. And then they are still keep the stories intact. True Island stories. So we say gratitude and salute. Yeah, man, to a look news vloggers again, commendation, gratitude and salute. Irrespective of no personal feelings out there. Yeah, man, we have to say complete respect out there with honor and power. Gratitude to the Aboriginal community. Straight across the board. Aborigines, perfect love. Aborigines, perfect love. It is amazing when we have to set precedent and step out here and share information. Them basic information, yeah. Only in an effort to make sure there is clarity. Yeah, man, and there is what is known as the law. And then you have the corporate policies. Now, the agents where enforce the corporate policies are actually and factually law breakers, obviously and evidentially, seeing that they chose to go outside of the supreme law of the land. So this is why we can say discrimination, whether it's racial or whatever, what it is, discrimination. And again, these guys are foreign to us as a people. You know what I mean? So, we don't know if they are clan members or not. We don't really know. We know there may be Quakers over there. However, we just share information, that should give clarity. You know what I mean? And should avoid a Ku Klux Klan lynching up there on Nantucket Island. Yeah, man, because those people doesn't look like us. And we have a lot of people that look like us in that location, but they're totally afraid. They're completely terrified on the island. Yeah, those people that look like us out there. I think Joel Jaguar is the only one that chooses to exercise his free will to be free as a free inhabitant. But these KKK out there have those dark-skinned people terrified, my people. And again, when I take a look at those locations, I say there's too much isolated woodland. So brother, you have to be careful out there. Especially with these, cult clan members. God, they'll never reveal that they are. But just take a look at some of these people. It is scary. So you guys need to, be mindful of your actions out there. Yeah, man. Salute, Jamaica, Perkins, Anna McKing, Bolinga, salute sis, Joel Jaguasi, Anna my lord. Yeah, man, true thick or thin, man. Fire or water. We have to step out there. However, again, you know the deal. You know what I mean? All our discussion privately, you know what it is and how it is. You know what I mean? I will keep that where that is. And step forward, bold and brave. No have no problem. You know what I mean? Yeah. Contending with this foreign construct in any form, any variation. Yeah. Paper war. Let's go. Your paper against my paper. Your documentation against my documentation. This is our level. This is our lane. This is our world. Law and order. Here we go. So you court clerk / clerk of court / prosecutor / inquisitor. Be prepared to present your insurance. Yes, that bond and the location of that bond. And we're going to request that formally. That's so you guys can ignore our request. And as we proceed on to discovery, it shall be interesting. You know what I mean? And it shall be a public display on our part. We don't have a problem. So it's just step-by-step information share. Yeah, a treatise on arrest and false imprisonment. Yeah, part 1. Gratitude again, people. We really can't stay all day. Gratitude.